Welcome, everyone. I'm so pleased you're able to join us for INCOMPAS's webinar on Post-Chevron, What's Next for the Communications Industry. I am Angie Kronenberg. I'm the president of INCOMPAS, and I have with me today some of the best legal minds in the communications industry. They also are INCOMPAS members. They're all partners at their law firms. They provide great legal advice to INCOMPAS and a number of our members, and I've worked with them for decades. So with me today is Russell Blau from Morgan Lewis, Michelle Farquhar from Hogan Lovells, Craig Gilley from Venable, and Chip Yorgaitis from Kelley Drye. I really can't thank you enough for joining us today and imparting your wisdom. I have a lot of questions for the panelists. I know the audience may have some too, so please use the Q&A feature below to post your questions and I will try to get to them. There's a lot to cover, so let's just jump on in. Craig, tell us what has been the lead up to the Loper Bright case, where the Supreme Court overturned a 40-year-old holding of deferring to the agency's expertise when their statute is ambiguous.
So there's been a lot of discussion over the past couple of weeks since the decision about the incredible impact that this decision is going to have on administrative law and administrative agencies, administrative state, and policymaking in Washington. But Loper many saw it coming, has to be seen in a larger context of the conservative legal movement and this conservative wing of the Supreme Court and their inherent skepticism of the administrative state and administrative power and rulemaking. And this case, along with about 4 other cases over the past couple of years, show that skepticism put into action to provide a check to the administrative state. It's built on a concept of reinvigorating the separation of powers built into the Constitution. It is a message to Congress that the court wants Congress to do the policy making, not the state, not the agencies, especially on big things, and that the deference that has been given to the agencies, growing ever since the New Deal, is to be checked. It is the crowning achievement of this movement, is the overruling of the Chevron deference to agencies in the Loper decision. But again, there are other companion cases that show the same movement towards checking the administrative state. Loper is the culmination. It is a big thing. We're all talking about it, and it will fundamentally change how our government has worked for almost 90 years since the New Deal. So there are 4 cases I want to talk about real quick that we get a context for where Loper falls. The first was in 2022 in West Virginia versus EPA. The Supreme Court invoked the major questions doctrine, saying that the courts have full review to review regulatory actions that have vast and political significance. There, the court explained that administrative agencies have no powers to make decisions on major questions of extraordinary economic and political significance unless Congress has very clearly given it the authority to do so. This case was the bellwether to the shift in administrative law that was to come over the next 2 years. Major questions can now be evaluated by the courts with virtually no deference to the agencies. Next was Axon Enterprise versus FTC, where it allowed defendants in regulatory proceedings to bypass the administrative process where there is a constitutional question by bringing a constitutional challenge directly in federal court. So instead of having to wait for the agency to finish its full action, this case allows plaintiffs to go straight to court, for example, where there's a takings issue, instead of having to wait years. So again, checking the power of the administrative agencies to take action, providing where there's a constitutional question, an avenue to go straight to court. This year, there are 2 companion cases. First, Corner Post versus Board of Governors, where the Supreme Court overturned 75 years of practice, holding that the 6-year statute of limitations contained in the APA to challenge an agency rule was triggered not by the issuance of the regulation, but from the date that a particular party suffered an injury result of the rule. This change allows affected parties to commence new APA challenges in courts to regulations that were assumed, old regulations that were assumed to be finalized and the statute of limitation had run, maybe even decades ago. So this opens up all sorts of old regulations to challenge. Finally, in SEC versus JARCSI, the Supreme Court held that when an administrative agency is using its enforcement power to seek civil penalties against a party, the target has a right to a jury trial in federal district court. There are some nuances to this, and it remains to be seen exactly how it will play out with each agency procedure. But now agencies will have to defend their enforcement actions more frequently in front of a jury, in front of a court, instead of just leaving it with an ALJ or within the agency. It is in the context of all these cases calling the power of agencies and agency power and agency action that we get Loper. And we'll talk about all the impacts of Loper because it really is the overarching, it's the culmination of all of this action. But taken together, all these cases create a new reality where parties affected by administrative agency actions have a lot more options to go to court, to litigate, to try to check the agency in a separate forum and to challenge regulations. So in that context, we get Loper. So I will turn it over. I think it's Michelle is going to go next.
Yeah, Michelle, give us a little bit more context about what was Loper about, what's the shift in the jurisprudence, and what's the standard now that the court's going to use to review agency decisions?
Sure. Well, under Chevron, I'll probably start there. The Chevron deference doctrine, as it was called, courts were required to defer to an agency's reasonable interpretation of an ambiguous statute that the agency administered. And this was done through a two-part test, which required courts to first decide that the statute was in fact ambiguous, and secondly, to decide whether the agency's interpretation was reasonable. So on June 28th, the Supreme Court in Loper Bright overruled this 40-year-old doctrine. Chief Justice wrote for the 6-justice majority, holding that the Administrative Procedure Act requires courts to exercise independent judgment in deciding whether an agency has acted within its own statutory authority. And courts can't simply defer to an agency's legal authority because a statute is ambiguous. So the majority referred back to the framers and even to Marbury versus Madison as envisioning the courts as the final authority on what the law actually says. They found that the APA is consistent with that approach and that statutory ambiguities are not implicit delegations to agencies themselves. And they rejected the idea that agencies would have any special expertise themselves in resolving statutory ambiguity. And they also expressed a lot of frustration about the many practical difficulties and substeps and exceptions and limits that had evolved over the 40-year history with Chevron. Finally, the majority held and spent a lot of time on this, that stare decisis and precedent did not require retaining this doctrine, given these many practical problems that I noted, and the flip-flopping by some agencies, and that so many statutory interpretations could be deemed reasonable by courts. And in fact, the Supreme Court noted that it had not relied on Chevron in its decision-making since 2016. So very importantly, the court stressed that it was not reversing any previously decided cases under Chevron and that had been upheld as lawful. So the previous court actions were still subject to stare decisis. So Justice Thomas concurred and stressed that Chevron was not just unlawful under the APA, but also unconstitutional because it violates the separation of powers, while Justice Gorsuch really focused in and highlighted some of the reasons why he believed Chevron was not entitled to stare decisis, And that's where some of the agency flip-flopping, like the net neutrality issues at the FCC, came into play. Then the dissent, Justices Kagan, Sotomayor, and Jackson found that the Chevron doctrine actually was correct, workable, and very appropriate, and far narrower than what the majority had suggested in their opinion. They noted that Congress had done nothing and could have displaced Chevron if they had wanted to, and they found that the court's decision had ended up fundamentally shifting the separation of powers now from the executive branch to the judiciary. So kind of taking the majority's argument and turning it on its head. So the good or bad news, depending on your point of view, is that this is not the end of judicial deference. There might be areas where the courts actually have deferred to regulatory agencies quite a bit. Some say maybe too much. Some say it's more deference light, but I'll list a few, most of which the court actually noted itself in its opinion. One is fact-finding. Agency fact-finding does get deference, including more scientific fact-finding under a substantial evidence standard. The second is express delegations, where the Congress says agencies shall determine, for example, in very clear wording, that we don't want courts making these decisions. We want the agency figuring it out, and they defer to the agency expressly. And that's viewed as an arbitrary and capricious standard. Another is implicit delegations, when we could see some increased litigation here going forward. These are more ambivalent words such as reasonable, adequate, appropriate, just, bona fide, that inherently seem to require a degree of judgment by administrative agencies. And Congress is essentially saying the agency should apply its best judgment. But that, again, might, and this was noted by the Supreme Court, but might be hard in some situations if it's not one of the specific words that's noted by the court. There's also our deference, where agencies are given deference in terms of interpreting their own regulations when they are ambivalent or ambiguous. And finally, Skidmore deference, which was again noted by the court. This is a very long-standing one from the 1940s or 50s, where the agency's power to persuade or put a little thumb on the scale is entitled to respectful attention by the courts. And again, it's not perfectly clear what it means, but it certainly could be broadened over time if there's no Chevron deference potentially. So some have argued that that could happen in the lack of Chevron. So essentially, what this all means is that there's independent judicial review of legal questions under the APA. They can still look to agencies for guidance, but not defer to the agency's interpretations. And some believe, and there are articles suggesting that this gives the judiciary a license to not sustain government agency decisions. And as Craig was noting, in the context of the administrative state and some of the judiciary who do not favor regulatory actions, this gives them a lot more leeway and power potentially, but there are other deference standards again in play. So it certainly is expected to bring about a lot more litigation, especially initially while the ground is still shifting.
Okay, great. Thanks, Michelle. So Russell, as we're looking at this in the broader scope, give us your perspective on how this fits into the overall scheme of how the Supreme Court's been shifting their view of the balance of powers. What are the other cases, and what should we be considering as regulated entities when we're thinking through our obligations that we're obtaining from the FCC and other agencies?
Sure. So as Craig explained earlier, the Supreme Court issued a couple of other significant decisions just within the same week as Loper Bright that really cut back on the powers of administrative agencies and increased the power of the courts to review those actions. And those were the Corner Post case involving the statute of limitations and the Jarkissi case that involved the right to a jury trial in enforcement matters. And for technical reasons, neither of those cases really affects the FCC, but what they are significant for is reinforcing the attitude of the court towards agency discretion in general. The concern that the dissenters had in Loper Bright and that some other people have expressed since then commenting on the decision is that we're going to go from a standard where when in doubt, the agency always wins to when in doubt, the agency always loses. I don't think it's going to go that far. It's certainly going to depend on which court a case goes to. Some courts of appeals will probably be stricter in reviewing administrative agency actions than others. Certainly not all cases. In fact, very small percentage of cases ever get to the Supreme Court. And so in many cases, it will be the Court of Appeals that has the final say in reviewing agency action. The DC circuit, where a lot of FCC cases get reviewed, has historically been relatively deferential to the agency. It'll be interesting to see whether that changes now. And of course, not all FCC cases get reviewed in the DC circuit. We have a number of very significant cases right now that we'll probably be talking about in the course of this hour that are pending in other circuits. And different circuits may take different views as to what the appropriate level of deference is. As Michelle said, the Supreme Court talked very heavily about Skidmore deference, which is the persuasive power of an agency ruling, and the courts are supposed to give respectful attention to what the agency said within the area of its expertise. And the court in Skidmore, and again in Loper Bright, reiterated there were 4 things that the court should look at in deciding whether an agency's decision should get respect. One is the thoroughness of the agency's consideration of the issues. Second is the validity of the reasoning the agency used. The third, and this one's going to come up a lot, is consistency with earlier and later pronouncements. And so certainly in cases where an agency has gone back and forth after each election and changed its policies, it's going to be much less likely to get deference because of that criterion. And then the fourth is kind of a catch-all standard about the overall persuasiveness of the decision. We're going to see a lot more arguments about those factors in future cases and a lot less about, was the agency's decision within the bounds of reasonableness?
Yeah. Thank you. What I often hear, and probably you do as well, because you're working with the same members that I work with, and that is we need certainty. We need to know what our obligations are. So each of you, give us a little perspective of what you're hearing from the industry and what kind of certainty, how is it going to change in terms of new rules that come out and everyone knowing what we need to do next to abide by those rules?
Well, I'll make a few comments, Angie. I think with regards to certainty, it's important to underscore, the others have hinted at this, that the court did not say that the agency is always wrong, right? So, there is the potential, and particularly, I think, in light of the Loper Bright decision, I think the agencies, the FCC, will look more carefully in trying to determine the best interpretation. They'll be anticipating what the courts might say in response to what they're doing, since they no longer have Chevron deference, because I think they have an interest in certainty as well. But at the same time, while the Supreme Court believed that eliminating Chevron and no longer giving deference to reasonable interpretations of statutory ambiguities would prevent every administration has a different view on what the statute means. One of the issues I see with regard to certainty that may develop, we have to wait and see, is that at least with some areas where there is an ambiguity and a court applies the best reading, whether that agrees with the agency or not, then you kind of have that locked into place, and as circumstances change, as industry changes, as the markets change, that puts a greater burden on Congress to then come back and change the statutory provision that's been interpreted in a way by the courts and locked it in. So, maybe there'll be an issue of too much certainty. I don't know, but there's also possible a ping pong match, although it's hard to believe that in the partisan atmosphere in Congress, of where Congress is more active and changes the statute more regularly rather than relying on the agency to interpret the statute and apply it to current circumstances.
Yeah, I mean, as I've done some reading, right, there's some who have suggested this is really great for regulated companies because now they can essentially challenge. And if they miss the opportunity to challenge when the order came out, perhaps they can challenge when enforcement is happening. So what further perspective on that?
So let me chime in with certainty. It cuts multiple ways. So if you're an entity that just wants to comply with the rules and know what the rules are, if they're in limbo because they're in litigation, there's less certainty. If you like the rules or you like what the agency has done and you want them to be certain, you don't like the idea that parties that don't like them can be challenging them in court forever and thus causing uncertainty. Now, if the agency has done something you don't like, the change in certainty is good here because you now have options. So before, there was certainty in that if the agency action was sort of in bounds in that reasonableness zone, there was certainty that you weren't going to win if you challenged it. So you felt like, I would counsel clients, oh, we can challenge, but it's sort of hopeless. So there's a lot of certainty in that, but now that's gone. Now you have options. They've given multiple tools here to people who want to challenge, and there's now that's good uncertainty because you want the ability you want options, and that's what they've given parties really negatively affected by agency action. So it does it changes the landscape, and depending on where you sit on any given issue, it could be good or bad.
Any other perspective on that?
Yeah, there's another aspect of certainty that comes up more often in other agencies. We haven't seen it so much with the FCC, but who knows whether they'll change that, which is non-acquiescence. The IRS, for example, does this pretty frequently. They'll take a position as to what the statute means, they'll litigate it with the taxpayer, and sometimes lose, and say, okay, we're going to follow that rule in this case, but we still think the statute means the other thing, and the next time another case comes up raising the same issue, we're going to litigate it again. And the FCC, in theory, could do the same thing if they lose a case in Circuit A because the court says that something they did was not within the meaning of the statute, and then a different case comes up that raises a similar issue. They could decide to take their chances with another circuit and see if they can get a different ruling.
Fascinating. All right. So before we get into the specific orders that the FCC has pending in court now that they're defending, I wanted to get perspective on FCC enforcement of rules that are already on the books. And also, like, what does this mean in terms of Congress? And can Congress change any of this finding by the court? Can they amend the Administrative Procedures Act? So I know I'm throwing a lot at you. What's perspectives on some of these questions?
Angie, I'll take a shot at the last one, have some thoughts on the others too. I think it's theoretically possible. I don't know how likely it is that Congress could seek to amend the APA in order to give deference back to the agencies, right? I mean, that's what you would expect a sort of democratically controlled Congress to do, because the majority decision was based upon the interpretation of Section 706 of the APA. While they were grounded in the separation of powers when they discussed it, they didn't find Chevron unconstitutional per se. That was the leaning of Justice Thomas and his concurring opinion, and to a certain extent Justice Gorsuch. But if Congress did move in that direction to amend the APA, then I believe that this question of constitutionality would probably come to the fore when that ultimately made its way to the FCC. On the other side, since this decision came out just a few weeks ago, there's about 20 Republican senators who have introduced or supported a separation of powers Restoration Act, or SORPA, which is designed to curtail what they perceive as agency legislative power by expressly placing a de novo standard of review in the APA. And one thing they've done, which sort of would impact, what happens on Capitol Hill and the relationship between Capitol Hill and the agencies, is they've launched a working group that comprised of senators, which has issued out requests to more than 100 agencies about how those agencies' processes will be handled following the Loper Bright decision. So, I mean, you definitely have two very different currents here in terms of how both sides of the aisle might handle the situation post-Loper.
Yeah, so it really also, I think, puts a light on the upcoming election, right? Where you have both chambers up for grabs in terms of who's in control, in addition to the White House. Any other perspectives before we move on?
Angie, you
Well-
asked about enforcement, and I think different folks have had a lot of different views on that. And I think a lot depends on the nature of the case and how settled the law is in that area already, as opposed to something new and being challenged for the first time in the enforcement context. That might give a lot more leeway to the parties. But a lot of times on the FCC side, some of these decisions that the FCC is enforcing are quite settled, and it's going to be more difficult at that point to challenge. But it certainly raises the bar for the FCC as an enforcement agency and they have a lot of power in that area, to make sure that they're clear themselves and that they're thinking about all the different ways the decision could be challenged, especially initially.
And today, or before Loper, it seemed as though there was incentive by industry players to try to settle disputes with the FCC versus going through, findings where they've actually violated the rules, and then they owe, the penalty. And so many have entered into consent decrees. And how does it change, like, parties' incentives to engage in the negotiation process with the Enforcement Bureau to get to a settled matter, or does it not? Do you think parties may still have an incentive to want to negotiate a settlement with the FCC?
I think a lot of parties will still have an incentive to want to negotiate a settlement if they can get a reasonable deal, because, litigating the issue is still going to be very expensive, time consuming, and you're certainly no guarantee you're going to win after all that. And especially for companies that have ongoing matters before the FCC, they don't really want to blow up their relationship with the agency over one enforcement case when they're going to be going back and time again for license renewals or for other transactions or other deals.
Yeah. And one
Yeah,
other,
yeah.
I'm
I was
sorry.
just going to add to that, you have to look at the the dollars, right? You always have to look at the money, and in terms of what's the potential, I guess, a combination of the potential, the fine that you might be facing based on the specific allegations of violations, and what that will cost you going forward as well in terms of continued compliance. So I think the corner post decision does not apply, as one of my colleagues said earlier, in the same way to the FCC, because the FCC is under the Hobbs Act, and their decisions with regard to rulemaking decisions are subject to basically a 60-day review period to seek judicial review once the rule becomes effective. And there is an open question raised by the corner post case. If you have an entity that was not in existence at the time the rule went into effect, whether in an enforcement situation or another situation, they might be able to challenge it and get a fresh look at the FCC's rule that's coming into place and their interpretation of the statute. If there was an ambiguity involved, whether that's a way to sort of do an end run around the stare decisis impact of an earlier court that upheld the FCC decision under the Chevron deference doctrine.
Angie, to go back to your question about how it impacts Congress and lawmaking,
Mhm.
you know, I mean, here you have the Supreme Court very clearly saying, or at least this is what they're trying to say, whether Congress gets it or not, is Congress, do your job, do the policy making, provide details, don't leave things to the agencies that are of importance. And so that sets up a situation. Let's say take like the Schoolhouse Rock version of legislating, where everything's perfect, and a bill goes through the House, it goes through the Senate, and then in conference committee, and then goes to the president for signing. In that perfect process, you would hope that there would be opportunity and incentive for committee staff and industry lobbyists to work together to clean up any ambiguities and to make sure that there isn't a future trap for an agency that implements a statute, and that everything is carefully done, and then it's all hashed out perfectly in conference committee before it's agreed upon and sent to the president. So that the incentive there is for Congress to take a harder look, to do more work to shore up the statutes before they go to the agencies for implementation. I think we talked about this the other day. The concern is that's not really how legislating is. That's not the standard anymore. It's been a long time since that has been. That major policy decisions end up in omnibus bills, get thrown in on trains that are leaving the station, and they're incomplete, and maybe things haven't been thought of, and you have 3 days to get everything together and get it before it becomes law all of a sudden. And it's in those instances that there's a lot of danger, for proponents of regulation, because things are not going to be perfect. Congress will not have done its job, and in the old world, that would have been, that's just ambiguity that the agency can hash out. In the new world, well, agency may not have that opportunity. Congress didn't speak. It's going to be it's going to end up stuck in court. So it changes the incentives and the realities of policymaking and legislating. So.
And that may be particularly strong in areas affecting new technologies, and that includes satellite and space. And some have said that really impacts the FCC's jurisdiction over some space issues, that NASA has more authority under statutes than the FCC might. And a lot of areas in AI, those may be very difficult. And even if Congress does step in and the agency takes action, there are other groups that come into play, especially the states, that might have more clear authority and less subject to litigation. So it may be in court for a while, and these are areas where some argue there needs to be the most attention, but it may be more up in the air.
And when we're looking at Congress too, there are political deals that are getting cut that are more major, right? But they do have some expertise, and sometimes they have agency employees that are on detail to the committees or to particular offices, kind of help them work through some details. But do we really anticipate that Congress is going to be able to solve this conundrum by providing more specificity to the agencies? Or do you think that's pretty much just not likely to change in practice, and we'll continue to just see more broader direction given to the agencies, and then more testing of how much the agencies will, as they go through the Skidmore and these other kinds of reliances, right? More testing of that kind of over time to see where the courts land.
So I don't think, unless I'm interested to other panelists what they think about this, I don't think that Congress has to provide every answer when it's legislating. It just has to be clear if it's going to defer to the agency. It has to be just really clear. We're deferring to the agency's expertise on this. It can't be some sort of, just generic, in all areas of, new spectrum allocation. The agency has that, but you provide exactly what the agency can and cannot decide is the job for Congress to do. So where there isn't a political compromise to be had, and the competing parties really do want the agency to solve it, or they want to punt on it, you just have to make it really, really clear. And that's like your job, to say, hey, this isn't clear enough. This needs to be clearer if it's going to survive.
Yeah, and so
Yeah.
I would anticipate then too, the congressional, I mean, Congress has lawyers on staff, right? And the lawyers on staff are going to be pointing out to them the risks if they don't say things that are that clear. That we're deferring to the agency on this particular matter.
Yeah,
There
I think
already are examples of statutes where Congress has been pretty clear about what it wants the agency to decide. Take, for example, the Secure and Trusted Communications Networks Act, which very clearly told FCC, publish a covered list, and here's what should be on it, and here are the decisions you have to make to determine whether a company belongs on the list or not. And there may be a lot of things to challenge under that statute, but what Congress intended the agency to do doesn't seem to be one of them.
Well, and I think, I mean, that was very specific. I think if you look at, for example, Section 302A, which envisions, which the FCC has done, the adoption of a variety of regulations in a variety of areas related to radio frequency devices and wireless stations from the standpoint of regulation of the airwaves, that was a little looser in the delegation, but I think that's pretty clear. I think what will no longer be the case is the commission will be able to point to two of its favorites, Section 201B and Section 4I of the Communications Act. Just that they're both similar in their broadness, but 201B, for example, is the commission may prescribe such rules and regulations as may be necessary in the public interest to carry out the provisions of this chapter. That's not going to be a delegation, I think, that will be sufficient going forward. I think it will have to be fairly specific, as Russell was saying, and that will be the job, not necessarily making the decision. In the spectrum area, a lot of legislation, you see that there'll be some sort of study that's done with NTIA and the commission to identify at least a certain number of megahertz or to be studied above or within a certain range. And then the commission within a certain number of years will adopt rules allocating at least so much for unlicensed, so much for licensed. I think a delegation like that, it probably has a very good chance of surviving, and it leaves still a fair amount of discretion in the agency which frequencies those will be and what the rules and licensing frameworks will be.
Great, thank you. All right, I wanted to move to the pending court challenges that the FCC is defending. So we've got litigation that's still pending in the Fifth Circuit with respect to the Universal Service Fund. How do we think that these latest cases, and Loper in particular, potentially changes the court's review? It's en banc at this point. The court's review of USF, its constitutionality, and the delegation of the USF to the FCC.
Well, as you said, that's a challenge to constitutionality. It's not a challenge to the FCC's interpretation of the statute. So technically, Loper Bright doesn't really even apply there. However, the court's attitude towards administrative agencies in general certainly is relevant to looking at that case. And I think that, Craig said at the beginning of the hour that, Loper Bright was in a way the culmination of the conservative legal project, but it may not be the last shoe to drop. The next shoe could be narrowing the non-delegation doctrine, which says that there are limits on what Congress can delegate to an agency, and that it has to provide clear limits and boundaries on what the agency can do. And that's squarely raised in the USF contribution challenge that's pending at the Fifth Circuit. And certainly if I were challenging the statute, the Fifth Circuit would be the circuit that I'd want to be in, because it's certainly the most conservative of all the circuit courts right at the moment. But it doesn't always, the Supreme Court doesn't always agree with it. So we have a ways to go to see where that case goes.
Yeah, I had never thought of it that way. That's really interesting. If you get the major questions doctrine invoked, you get Chevron knocked down in Loper, and you get that decision. I mean, that is really a tough road for agency action at that point.
All right, moving on to another hot topic, the net neutrality order that's pending in the Sixth Circuit.
So let me just say, I think that is going to turn on major questions first and foremost, and then get to Chevron. They signaled that in the EPA case, the West Virginia case, when they were arguing major questions. The Supreme Court was all over net neutrality, the history there, is signaling that, hey, this is a major questions case. So it faces two big hurdles, not just the Loper decision, but the major questions doctrine. So
When the Obama era net neutrality rule was appealed to the DC Circuit and there was a petition for rehearing en banc, one judge dissented from denial of rehearing en banc, saying this is squarely a major question and we need to review the FCC's authority. And that judge was Brett Kavanaugh.
yeah,
Right.
it was that dissent that kicked this whole thing off, really.
Right.
Yeah. So
And
the
that could be another one that, you know, eventually Loper Bright doesn't come into it if, in fact, on the major questions doctrine, the court decides that there is no authority for the FCC to decide the question in the first place. Then they don't need to look at what it is that the commission did decide, which raises the issue of, well, what happens next? I mean, status quo until Congress acts.
Yeah, and the FCC does seem to be trying to avoid Loper Bright altogether, in its own interpretation of what the service is under the definitions in Title II, right? So I think that the major questions doctrine may be the biggest hurdle it's got to face from the Sixth Circuit.
But you could get decisions that are belt and suspender that are both Loper and major dissent, and like, I don't know where to go from there. So
Yeah, and it's good to reiterate, I think, that on the one hand, Loper Bright doesn't mean that the agency is always wrong. And two, the agency may think it did the best reading of the statute. And if you agree that there's some objective best reading, I may disagree with you. But the court may disagree with an agency that believes, look, we didn't rely on Chevron or permissible or policymaking. We looked at what the statute requires. And the court may disagree. It goes both ways.
Okay. All right, moving on. Oh, sorry, Michelle. Go ahead.
I was just going to add on that point, there was a recent article post-Loper by Cass Sunstein, who a Harvard law professor, very active in administrative agency work. And he said the real interesting thing about Chevron is that even liberal courts looking at conservative agency actions and vice versa, conservative courts looking at liberal agencies, under Chevron deference, they affirmed a lot more decisions than when they didn't apply Chevron deference by a huge margin, up to 40%. And so he said that protective shield that Chevron seemed to have given the agencies within the court structure was highly protective, no matter how you were looking at it. And he actually shows a lot of interesting data on that point. So.
Yeah, in fact, Chevron, where the genesis of Chevron in it was like 82 was because the Reagan administration was trying to deregulate and was being thwarted and stopped all over the place by liberal judges. And it was a decision that was thought to protect the ability of a conservative administration to deregulate. And in 30 years, I guess 40 years, it flipped. And I think that there was a lot of people in the conservative movement that thought, oh, this is really bad, unintended consequence type decision. So.
Okay, I'll move on to other FCC challenges. The digital discrimination order that's pending in the Eighth Circuit. What do we think of it?
I think that's going to be subject to a lot of different questions because of the lack of clear statutory authority, arguably. You've got non-delegation, you've got you've got a lot of different issues probably on that one, but and just some of the principles seem to be vague in terms of how they would be effectuated. So I think that will be an interesting case to watch, with or without Loper.
But I think with Loper, you're going to have many issues there looked at in a different light. The term comparable terms and conditions, where the you know, the commission interpreted that to include rates. And so the question is, does the best reading of terms and conditions include rates? Will come up, as well as the scope of you know, parties that facilitate the provision of broadband, like MTE owners. You know, is that within the scope of the statutory provision? So I think there'll be a little bit of a field day there with trying to apply Loper.
It's going to be really complicated because it brings in a whole set of jurisprudence around disparate impact that I don't think any communications lawyer is expert in. That is very complicated, and that is all going to be intertwined in that case.
All right, and then we just had a new vote today on the E-rate Wi-Fi hotspots, where I think came into the record in ex partes that this is you know, outside of the scope of the FCC's jurisdiction, because the E-rate program is specific to service at schools and libraries. Give us your perspective on that.
I think that that's definitely going to be an issue on appeal. I mean, two Republican commissioners dissented from that order and said that it was outside the FCC's authority. The FCC took some language in the statute and interpreted it fairly far towards the outer limits of reasonableness. And, you know, it'll be certainly within the authority of a court to take an independent look at that and decide whether they think that was a fair reading of the statute.
Okay, great, thanks. All right, and then one question we've gotten from our members is, does this impact the NTIA's BEAD NOFO and the implementation of the BEAD program by the states and those state approvals that have been going on with respect to their broadband programs and the implementation of BEAD and the grants that will be happening under the Infrastructure Act?
Nobody wants to jump in.
And then, did I
It's so
stump you?
complicated.
That's
It's
a
so complicated. It's so complicated because you got state and federal, and then, you know, only a third of the states follow a Chevron structure.
And Congress, when it enacted BEAD, did give NTIA in particular a lot of protection, and only in very extreme circumstances would it face seemingly liability. So I think that is helpful. But to the extent that they adopted a low-cost service approach that wasn't necessarily anticipated, that could be at issue. But again, the state and NTIA working together on this, it does make it more complicated than your more traditional. And certainly it's not the FCC, so they don't do as they do grant programs, but not as many rulemakings or regulation in that sense. So it's a different structure within the agency itself.
Oh, great. Thank you. All right. I'm going to go over to the folder just to see if we have any questions. No open questions from our attendees. Okay. Well, this has been really a great session. Do you have any closing thoughts that you'd like to leave our audience with?
I have two. One is that the courts are going to be a lot busier, and there's just going to have to be things, because the different circuits are going to come out in different places, and it's going to be a hodgepodge. There's going to have to be a slew of cases that get to the Supreme Court to clarify the nuances here in any given area of law. And then my second thought is that from a practice standpoint, in terms of counseling clients and in terms of being a client that is adversely or positively affected by regulation, is that this change does give you more arrows for your quiver. Like, there are options here that were not available a year ago. And so there are arguments that will be amplified in briefs that would have been given maybe a paragraph before, because this new landscape gives you more traction in fighting an agency in particular areas. So, you know, you spend less time on just some pure statutory argument and more time telling the court that either the agency didn't have the authority, or they overstepped, or there was, you know, they were wrong. Like, you just wouldn't make those arguments before. And now you have now you have an ability to do so. There is comfort in that. So.
And from that standpoint, I think the GC's office at the FCC and all agencies will be busier too, because they'll have to think harder about how to approach issues. And I think they'll be getting more visitors. I think in many cases where it matters to my clients, I'm going to make sure that they visit the GC's office too and look how the GC is thinking about defending a decision that we support, or the other way around if we don't. But I think that office will become more important rather than it going forward.
Okay.
And
Looks like
just to,
uh-huh.
I'm sorry, Angie, just to sort of round that out with the third big player in this whole discussion with Congress, I think lobbying may take a different turn there as well. It may not be, fundamentally different, but I think the approach may involve more subject matter expertise on the Hill, in addition to lawyers and lobbyists, both on both sides, both within the members' offices and on the committees, but also among people that are lobbying on the Hill, because now what comes out in terms of legislation is almost like the first step in rulemaking. We're so used to rulemaking, maybe further notice of proposed rulemaking, and now that shifts a little bit earlier in the process, I think. As policymakers and lawmakers want to have their legislation presumably upheld by the courts and the agencies implementing actions upheld by the courts. So I think it all starts earlier and more intensely with congressional lobbying.
Mm-hmm. Mm-hmm. And then the lobbying of the agency too, while they're looking at rulemakings, right? Any thoughts about the obligation of parties to be raising with the agency their concerns about how it's going to be viewed by the courts under the new jurisprudence? Or can they just enter an appearance, make their general points, and then leave for the court challenging the FCC?
Well, I think overall you have more vulnerability on agency decisions on average. It would seem going forward. We'll have to see how that exactly plays out. So I think balancing out sort of policy considerations, et cetera, is to an even greater extent than it has been how this will survive in light of the Supreme Court decisions.
Yeah.
Under the Communications Act, you can't raise an argument in court unless you first presented it to the FCC, but you kind of only have to go through the motions of presenting it to the FCC. And once you've gotten it on the record, then you're free to litigate it.
Yeah. Okay. That's a good reminder. And then we did get a comment in the Q&A. I don't know if you saw that. Carl Henry was commenting on the Fifth Circuit's current en banc of the USF constitutionality. And he's like, just a reminder that the Supreme Court already turned down the cert request from Consumers Research on the USF-USAC litigation. Consumers Research has said that the 6th and 11th Circuit decisions against its arguments portended a split with the en banc Fifth Circuit decision that, of course, hasn't been issued yet. So always a good reminder of where we are in
potential
process.
Future circuit split is a lot different from an actual circuit split.
From
so
actual, yes.
Past performance is no indication of future results.
Yes. Okay, that's all we had in the Q&A. I really appreciate, again, you attending, giving us your expert legal advice. All of this really great commentary, I think, will help us. But I know this conversation is not going to end, right? We're really just beginning. And just want to emphasize to our audience, when you're looking to figure out these issues, couldn't highly recommend these people any more than I already do, which is these are the lawyers you want to be talking to make sure that you fully understand all of the tools that are in the tool chest, all of the arrows in your quiver that you have available to you. And if you have any questions for your trade association about how you should be considering things, we're always happy to answer it, but these great lawyers are available as well. Thanks again, everybody. Hope that you have a really great rest of the day. Bye.